Evidence Act. This is a very old act. As you can see, it was formed in 1872. But still today, it holds true in every sense. Now, why? Because this is the crux or the basic act of litigation. Now, what is evidence? What do you understand by the word evidence? Simply, it means proof. For example, your mom tells you not to eat chocolate and you go out and eat. When you come back, she says, oh, you had Cadbury, right? What do you ask your mom? How do you know? Do you have any proof? Can you prove it? And she shows you some spot on your t-shirt. What is it? It's an evidence. It's a proof that shows or which proves that you have done that act. Okay, so don't be scared about Evidence Act. It is very simple. It is very precise and small as compared to CPC, CRPC, and IPC, as you all know. But in Evidence Act, as far as your exams are concerned, you have to remember certain sections which are important. I have noted down in my PPT today, and I will tell you one by one. Now, you need to know the definition of evidence, because somewhere in your answer, you may include that. What evidence means? So, the term evidence means anything by which any alleged matter of fact is either established or disproved. That only means that something is proved, yes, or not proved, no. Anything that makes the thing in question, that means you're arguing over a fact. If that thing is evident, then it is evidence in the court. Now, evidence comes into picture when you go to court with a case. You have to prove your point. You say 1, 2, 3, 4 are my contentions. These are my arguments. But how do you support them? You can't just say A killed B. You have to prove it in the court. And for that, you need evidence. So evidence is the spine of litigation of most of the cases, may it be civil or criminal. Doesn't mean that it only applies in criminal matters, like, for example, murder, theft, robbery, etc. It also applies in civil matters where, say, for example, A has given property to B through gift or through will. But how do you prove? Unless you have the document. In simple terms, the paper. Okay, so that's your evidence. Tomorrow, if there is a dispute, you go in the court, you have to show that. Now, if I have gifted you something, you should have that proof. Tomorrow, if I say, no, I haven't gifted you, what is the chance that you will be able to prove? So you have to have something in your hand in the name of proof, which you can submit as evidence in the court to prove your point. Next slide. So I have noted down some important definitions which you need to know for your exams. Section 3 is the interpretation clause, which talks about fact, relevant, facts in issue, document, evidence, as you can see. Now, these are certain terms you need to understand the whole Evidence Act. Fact is something that you are stating, okay? That, say, for example, I said, you have eaten a chocolate, is a fact. Next is relevant. How relevant is it in your case? That becomes relevant only when it is connected with other things. Okay, so if you read your definition of relevant in your Bare Act, you will come to know that relevancy comes into picture when you're talking about some fact. Now, say you have not eaten the chocolate and your friend has eaten the chocolate, then the mark on your t-shirt doesn't remain relevant when your mom says you have eaten it. Okay, so that's how it is interpreted. Next is facts in issue. Now, there are certain things which are to be included and excluded when it comes to proving a fact. So, facts in issue exactly tells you what it is about. You have an illustration in your Bare Act. I would suggest all of you to have Bare Acts in front of you so that you understand better and we go faster with this. A is accused of murder of B. At his trial, the following facts may be in issue: that A caused B's death. Okay, B died because of A. A intended, so that means B was killed with an intention in mind. As we all know, in criminal law, there is something called as mens rea. That means guilty mind. So if you don't have an intention, it could be a sudden provocation and your case could take another turn. So this intention, having intention in your mind, is a very important point here. A has received grave and sudden provocation. Like I said, it could be a on-the-spot action. Okay. somebody just rushed towards you, and in that whole scenario you pushed him. That is something suddenly that has happened. You didn't have it in your mind, you had no intention, you had no clue that you're going to push the person, but you pushed him. So that's sudden provocation. And lastly, A, at the time of doing the act which caused B's death, was by reason of unsoundness of mind, incapable of knowing its nature. Now, as you know, in criminal law, children, infants, and infirm, that means who have got grave diseases, they are looked upon in with different thought. They are not looked at like hardened criminals, as we call it, right? So here we are talking about unsoundness of mind. So if you have an insane person in front of you, he comes and he slaps you, are you going to say he did it with an intention? No, because he is not able to take decisions on his own. He just did it because he felt like doing. But if you and me go and slap someone, what the person will do? He will take a step behind and then give you one more slap on your face, right? So that's a different scenario altogether. So all these factors are important in proving the case. So that is the facts, which are factors. In issue is something that is in consideration, under consideration with respect to a certain act that has taken place. Okay, we all understand document includes a lot of things in Evidence Act. Okay, so that could be letters, figures, marks. It also includes maps or other drawings. All these could be documents. Doesn't necessarily mean it's your birth certificate. Yes, that is also a valid document. Okay, but there are certain things which are included, like I just mentioned now. So anything that is in writing basically is a document. It could be in a printed format. Okay, you take a photocopy of your question paper, last year's question paper, that's a document, it's in writing. Or it could be photographed. As we all know, we are using a lot of apps to convert things into PDF, right? That could be also a document. Even a document could be something like a map, I said. Okay, so you are on a treasure hunt and you have a map with you. That's a document. Okay, so next is evidence. I've already told you what is evidence. You have to know the definition of evidence from Bare Act. Okay, because if you include that in your answer, you will get very good marks. Remember that. That only shows and tells the paper checker that you have understood your subject well. Okay, so as I told you, in evidence, basically it's about the statements that are made. Okay, so broadly speaking, there could be two types. One is evidence is documentary. Okay, so you have submitted certain things, like for taking admission in your law college. What did you submit? You submitted your previous year's mark sheets, your graduation mark sheets. You had, if you have a gap with your education, say 1 year, you might have given gap certificate. So all these are evidences. You're giving documents for taking admission in the course, right? So that is one, documentary. And second is somebody has seen, say for example, A slap B and C was there and he has seen the whole thing that happened. Now he goes in the court and he says, yes, I saw A slapping B. That is witness. Okay, so he is presented in the court. His statement is evidence, which is recorded in the court. Okay, so basically evidence is all about statements, documents. Earlier, when this act was made, there was nothing called as electronic, right? But then later on, when we had all electronic gadgets coming into picture, we have included electronic records, electronic evidences as well. So if you mention that in your answer, great. Next is proved. Now, these three terms, proved, disproved, and not proved, are very important to understand and also while writing your answers. So something that can be proved considering all the facts and all the logic that you can put into is proof. Something that, some circumstance that you can prove, essentially is called proved. Disproved is something which you cannot prove, right? And not proved is a fact where it is neither proved, neither disproved. Now, let me tell you very honestly, this is from exam point of view, for writing in your exams. Just remember these words and go and write it. Okay. Not much of a thought to be given here, but if you include in your answer, best thing that you can do for yourself. So remember, just understanding these terms and putting it down in your paper will give you good footing as far as marks are concerned. Now we come to section number 4. I have included may presume, shall presume, and conclusive proof. Now, see, there are certain cases where there is evidence, there is a proof, but is it really sufficient to prove that the person is guilty of that crime? Because law says that unless a person is proven guilty, he is innocent. He is presumed to be innocent. Okay. But for proving that also, that should be beyond reasonable doubt. Reasonable doubt means that any person with common understanding and a normal brain understands and knows that a thing has happened, an act has happened. He should be able to put an inference that yes, crime has taken place. Unless this fact is proved, there is no doubt that A has committed a crime. Unless that is proved, he is presumed to be innocent. So this all thing is called as conclusive proof. Okay. So you have to have sufficient evidence against a person. You cannot just catch hold of a person and say, okay, he's done the crime. No, right? And this is where evidence act and understanding of evidence comes into picture. What all things can you really use as a tool, as an evidence in the court to prove your case? Now, may presume and shall presume. May presume, in the act it says that the court may presume a fact, okay, a certain fact that A slap B. This is the fact. May presume, it may either regard such fact as proved unless and until it is disproved, or may call for proof of it. Means that unless and until it is not proved at all, the court presumes that it is proved. Okay. And if the court feels that there has to be more evidence in this, sufficient proof, then they may ask for more evidence and they may try to understand and get more proof from the investigation. Okay. Shall presume is whenever the court presumes a fact, it shall regard such fact as proved unless and until it is disproved. So in this case, it all relies upon the understanding of the court. Okay. So they shall presume such a such fact. Shall is a very important word here. They ought to presume that unless the person, so say you are for the accused and you, who will be opposite you, the prosecutor, right? So you are fighting against the state. The public prosecutor, commonly known as PP, will be fighting the case for the state. And unless the PP proves that you are wrong, the accused is guilty, the court is under an obligation to presume that whatever you're saying is true. Okay. So this is the way how court functions. So understanding of evidence, just keep it simple and related to common examples like A slap B or A committed theft. These are little examples which you can write in your exam, which will give an understanding to the person who's checking your paper that you have understood the subject well. Second point, it's not important to include your bare act language in your exams. Okay. Now, here I have imbibed certain points. If you follow this and if you make your answer in such a way, if you structure it in such a way, I believe you will really score well. Okay. So, always it's a thumb rule. You should write your answers in distinct points. Okay. So if you have say 4 points about the answer that you are attempting, if you write 1, 2, 3, 4 and keep elaborate and make 4 paragraphs distinctly, you will get better marks. If you instead of writing it in paragraphs and your answer keeps on running in pages, that will not make sense. It will not help you in getting marks. So my first thumb rule would be just explain this in simple words. Okay. You know the concept well, you've studied for so many days and we are trying to cover everything in this revision. So you know what it is about. Don't get into the bare act or your textbook language. Just express the idea in your words, in simple words. If you can imbibe all the relevant sections of that answer, very good. Secondly, you have certain illustrations in your bare act. If you include them, it's going to be amazing answer. Now, illustrations are very easy. Like I told you, A slapped B, A killed B, A committed theft, C saw him, these are illustrations. So write them. If you don't know case laws, that's fine. Illustrations give an idea that you are writing, you're knowing what you're writing. If you write a case law, then you will like score the best marks. There are certain case laws in this act which are repeated in many of the answers, and there are only 4 to 5 such case laws. One of them I am going to tell you today, other 4 I'll tell you tomorrow. So most of the answers, if you write even one case law and write the idea behind why the case law is included, then it is going to be a nice answer. Give examples if you are not able to remember illustrations or case laws. Example is you can write any random name, say Preeti, Slap, Sakshi, that kind of a thing. And if your concept is clear, only then go for writing examples, otherwise don't. Next is writing conclusion to your answer is very important. Many of the students miss writing this. What is conclusion? Conclusion is basically what you have gathered, what you have understood from the concept that you are writing about. So basically, if there is something called as admissions, you need to know what it is, and to express your thoughts on it, you need to understand that. So write a conclusion, why it is crucial to evidence act. Say, for example, you've written about documentary evidence, you've written a long answer. And towards the end, you write a conclusion as to why documentary evidence you feel is important and why is it included in Evidence Act in first place. Because documentary evidence is a conclusive proof. Nobody can question that. Your birth certificate is your birth certificate. For example, Sakshi was born on 1st January 1990. Who can dispute that? No advocate can come and say, no, Sakshi was born on 1st of February 1980. Nobody can say that. Your birth certificate is your birth certificate. So basically, having the idea of why that concept was included in Evidence Act is what you're going to write in your conclusion. As I said, write point-wise, just keep it very simple. If you have time, if time permits, if you are fast in writing, penning down your points, I'm sure you will have 5 to 10 minutes towards the end. You can just go through. Either you can underline as you write. Just underline important words or the sections. Wherever it is possible, just do that. And you know that, yes, you have noted down your answers very nicely. Okay. So now we have something called as relevancy of facts from chapter 2. Now these are certain sections. If you see in your bare acts, there are a lot of sections, but these are 5-6 sections which you should include in your answer when you are attempting an answer for a question for relevancy of facts. So section 5 talks about evidence which may be given of facts in issue. We now know what is facts in issue and relevant facts. Section 6 talks about relevancy forming part of the same transaction. Now let's see one by one. Basically, all these things boil down to one important fact, that you want to prove your case, okay, because you are fighting in the best interest of your client. So where evidence may be given of facts in issue and relevant facts, the point here is that in any suit or proceeding of the suit means it's a civil matter. Existence or non-existence of every fact in issue or of such other facts are declared to be relevant. So you have to prove it in such a way that they are relevant to your case. Say, for example, you are talking about a case where there is theft that has taken place. And suddenly you give some evidence or you try to prove a fact that there was murder involved. Now, if it's a simple theft case, you cannot include a fact that A had knife with him unless that is important to your case. Say, for example, murder was committed with a knife and there was no knife in the theft case. Then the knife will become irrelevant in your theft case. Okay. So these are certain evidences, right? Knife is your evidence, a very important evidence in the murder case and not in the theft case. So it has to be relevant to your case. That's the point. Facts in issue are all those facts which support your story when you are proving your case. All right. So section 5 talks about evidence with respect to these two factors. Section 6 talks about relevancy of facts forming part of same transaction. That means there are some, say, 2-3 things that have happened at the same time and same place or at different times and places, but it is forming, it's like a chain and it is a part of the same transaction. Say, for example, a murder was committed. Okay, now this is a real case of a journalist where she was watched upon by a guy to understand her daily timetable. Other person was keeping a watch to know where she stays. Other person, third person was keeping a watch on what time she visits her office. And they almost came to know what she does in a span of time of the whole day. And then they took advantage of she being alone and she was shot dead right in front of her house. So all these, whatever that 1, 2, 3 people are doing, it is forming a part of the same transaction. So they all together are doing this to do what? To kill her, right? So it is a part of the same transaction. So now these facts, okay, fact number 1, what A has done, fact number 2, what B has done, they have performed different things, but they are all relevant. Okay, so section 6 talks about that. Section 7 talks about facts which are the occasion, cause or effect of facts in issue. Now here, what do you mean by occasion, cause or effect? Occasion is, so A has got an opportunity to keep an eye on her. Okay, that's the occasion. What's the cause? Because they want to kill her. That's the main thing that they have in their mind, right? So the cause of this thing happening is the idea of them killing her. Okay, then they took the opportunity, and the effect is that they murdered her. Okay, so these facts which you put in place to justify the opportunity, the cause, the intention, and the effect of the actions that they have taken, these actions that they have taken and related actions what they have done. Say, for example, they bought a pistol. That's fact in issue. Okay, so section 7 talks about that. Section 8 talks about motive, preparation, and previous or subsequent conduct. Now, motive is, as I said, you have a mens rea, you have something in your mind, you have a motive. Now, today, now your motive is to give your best in the exam. That's why you're attending this session. Preparation, what did you do? You wrote down answers, you're noting down points, you may want this PPT for your last minute revision. So that's preparation. And previous or subsequent conduct. Now, what is previous conduct? You have attended your college, you have attended all your lectures, you have put in your brain, you have read the Bear Act. That's your previous conduct. And what's going to be the subsequent conduct? You're going to revise this today. Okay, so that we are well prepared for tomorrow's lecture, and then you will do your best in your exams. So that's motive, preparation, and conduct. Section 10 talks about things said or done in common design. Now, this is basically related, somehow related to CRPC, that's Criminal Procedure Code, but it's included here because many of the sections in Evidence Act go hand in hand with CPC and CRPC. Okay, because they have to somewhere connect. How will you prove your case? Now, when you say criminal law, it's not just evidence. It's IPC, which tells you, defines all the crimes, punishments that can be given to the accused. CRPC talks about the procedure or as to how you should conduct the whole, what's the process, okay, right from A to B while proving, or rather while what happens in the court. And Evidence Act is how you prove it, right? So all many of these sections are connected with each other. So now what does section 10 talk about? It being in common design. So basically, there is a conspirator. Okay, now of course there is a crime happening. So there is somebody or somebody's brain who's thinking that a thing has to be done, an act or a crime has to be committed. And so he is called a conspirator, right? So he may put 3-4 things in place. He may just note down one, step 2, step 3, step 4, all these have to be done. And he may tell these things to some people. He may allot that work. So they all are doing it for one common intention, right? So all those things said or done in common design are a relevant fact. Now, why are we talking all this since section 5 is to understand what is relevancy of facts and what is it exactly. When you go to the court, you are going to state 1, 2, 3, 4 has taken place. 1, 2, 3, 4 are facts. And how are they relevant in your case? That you're going to prove. And that's the reason why section 5 to section 14, it talks about how you can prove your facts or your evidences to be true and to be considered in the court of law with respect to your case, which may go in your favor. Okay. So that was section 10. Section 14 talks about facts which show existence of state of mind or of body or bodily feeling. Now, see, it's very difficult to understand what's going on in someone else's mind, right? Say, for example, Swati wants to steal Rahul's pen. Is Rahul going to come to know? Unless it is stolen, he may not even come to know that Swati stole it, right? But he is not aware of it. Now, this stealing of Rahul's pen is a state of mind in Swati's mind, right? It's in Swati's mind. So that's a state of mind of her and not of Rahul. And he will not even come to know about it. So the fact that she stole it shows existence. First of all, there has to be some motive. You should have a desire to do something, and then you will do it, right? So when it is done in an illegal manner, or it is some act which is barred by law, it becomes a crime. So that having that state of mind, in very common terms, very loose terms, what we call it as mens rea. Mens rea is included in a state of mind. Okay. So any fact that can show that there was something going on in Swati's mind is relevant as far as section 14 is concerned. So say you may say you were asked by the teacher, do you know that Swati stole Rahul's pen? You may say, no, ma'am, I'm not aware. But yeah, she was fighting with him. Unnecessary fights. Then suddenly she may have expressed her desire to sit beside him on the shared table because she wanted to steal his pen, right? So that these are certain facts that you may state will become important and relevant as far as section 14 is concerned. And section 12, I've written it little separately because it is as with relation to civil matters. So it says about suits for damages. So you may have heard about defamation cases, right? They don't really follow a criminal procedure. They may just ask for a compensation where the person is not interested in penalizing the person or putting him behind bars. But only, say for example, A has spoken bad about B. B is furious. He says, what the hell is going on? How can he blabber something like that about me in the office? Okay. So his image is tarnished. He says, I want a compensation. So it is a suit for damage which is being occurred with respect to his image in the office. Okay. He's the boss and people start saying, oh, he is such a person. So his image has got tarnished, right? So that is a suit for damage. And what kind of facts can be put across to enable the court to determine amount is relevant. Why? Because say for example, he is a CEO of the company. He will ask for more compensation. Say if he is a peon, poor fellow, nobody's going to ask. They will say, okay, give him some 5,000 and wrap it off, right? You can't give such an amount to a CEO or a VP of a company. He will say, oh, my image is bigger. I am with so many people who are VPs of other companies. What are they thinking about me? Tomorrow, if my image is tarnished, they will think bad about the company. So it's gonna have a relative damage to a bigger organization, and he will ask for compensation maybe in lakhs. So that's what section 12 talks about. Now we'll look at what is admissions. Now you will be surprised to know I've written chapter. Okay. Now these chapters, if you include in your answers, it's going to really help you in getting marks. And all these important topics are in chapter 2 itself. Most of them are chapter 2 in today's session. So let's see what is admissions. Now, all this while when we were not a law student, admission was only pertaining to school and college admission, right? But what did it mean? It meant that you have submitted certain forms, certain documents, as I mentioned earlier, which is your mark sheets, and you have approached a school or a college to get admission into it. What does it mean? You want to study there, right? So basically that means that you are giving your evidences for taking admission. Now, how is this admission different? What is an admission? In first place, section 17 is important when you attempt this answer. I believe after writing a little gist about what the admission is, if you have by hearted or if you can, and write the definition of admission, which is given in not only admission, even other topics in given in the bare, then it will really reflect very well in your answer sheets. So let's see what is the definition of admission. Admission is a statement which suggests any inference to any fact in issue or relevant fact, and which is made by any person and under circumstances here in after mentioned. So it simply means that admission is a statement. That's it. Other all words are just showing that it is relevant to your case. One. Secondly, that means it's a fact in issue. And secondly, it talks about how it is important as far as your circumstances are concerned. Now, it also says that that statement could be either oral, that means someone else has talked about it, either documentary or in electronic format. Say, for example, let's see what statement, oral statement. What is oral statement? I may come and tell your mom that, oh, Swati is a good girl. She is a very good student. Your mom will listen to me. Why? Because I'm your teacher. She will say, okay, now the teacher has come and told that my girl is a good girl and she is a good student. That means she is studying well, right? So this is a statement, oral statement, and it is admitted. It is on face, your mom is going to accept. If someone else, say your friend comes and tells your mom, she may not pay that heed. She may say, okay, she is my girl's friend. She is going to say the same thing. Both are going to support each other, right? So that's the difference. Second is documentary. What is documentary? Admission or a documentary statement as far as a thing to be proved that you are a good student. Your mark sheet, you score A+. Your mom is going to say, okay, my daughter is a good student, right? So that is admitted. Admitted as in it is accepted, okay? And last is in electronic format. Now, as I told you, when electronic gadgets came into picture, electronic things were included because we have something called as electronic evidence as well. Say, for example, what is electronic evidence? Say, for example, you have a CCTV footage. You have a video recording. A slab B are common example. And you have a CCTV at your office. And you have actually captured that incident. When you submit this video in the court, it becomes an electronic evidence proving the fact that A slab B. You don't need anything. You all can see that that act has happened, right? So that's admissions definition. Section 18 talks about admission by party to proceeding or his agent. Now here there are two things. One, party is who? A versus B is a case. So A and B are parties, okay, to the proceeding. Proceeding is the case that is going on in the court. So any admission that is made by the parties themselves or who is agent, he is a representative, authorized representative of either of the party. So say for example, A versus B is going on. A was in critical condition. Okay, he was very sick, say 90 years old guy. While the case was going on, A died. So who will be in the case now? A has gone. A versus B. A is not there. So now legal representative come into picture. So most 99% times it's the legal heirs, successors of that person. Okay, so he is an authorized representative of A, and the case will go on. Most likely this happens in civil suits, property matters. So it goes on for little longer, and people are already old, they lose their lives, things happen. Okay. Section 20. Section 20 talks about admissions by persons who are expressly referred to by party to suit. Now, suit means again it is civil, property matter. What is it saying is that it is this admission is done by reference. Okay. And it has to be taken into consideration because it is a statement made by person who has expressly referred for information. So the person has come into picture and he's giving you a relevant fact or a document or a statement which is proving the case, right? So you can admit that fact. That is what section 20 talks about. Say there's an very nice illustration given in your bare ads. How is it a relevant statement? We'll see. The question is whether a horse sold by A to B is sound. Sound means the horse is in good health, is not mad. Okay. Because once horses sit down or if they go insane, they are shot dead. They are no more used for whatever purpose. Okay. So that's what they mean by horse being sound. A says to B, go and ask C. C knows all about it. So now C's statement, why is he saying C? Maybe because A is selling it to B, but A is not an expert in horse. His horse health, say for example, if you say with respect to health of animals, there is something called as veterinary doctors. Like we have normal human doctors. Like that we have doctors who have studied medicine for animals. So C could be a doctor, a veterinary doctor, and A tells B that you should go and approach C to understand the health of horse. So C's statement is an admission. A cannot confirmly tell. He is not in a situation or he is not in a position to assert, to tell, to confirm that A is in good health because he is not an expert, right? So C is an expert and his statement is taken as admission. This is what section 20 tells you. Section 21 talks about proof of admissions against persons making them. Now, what does this mean? This only means that these kind of admissions are relevant and they may be proved against a person who is making them or his representative. We saw how representative comes into picture, but they cannot be proved by or on behalf of the person who makes them. And they have given certain conditions. Okay, so this section was my conditions. First part is talking only about how the admission is to be done or how is it relevant. Now, what are these three conditions? One, it is talking about somebody who's dead. Second, it is talking about a statement of existence where it is talking about state of mind of the person, whether it is relevant or not. And thirdly, it is talking about whether it is relevant as an admission or not depends on whether it is proved or not on behalf of the person who is telling. Okay, so it simply means that in whatever conditions or whatever situations, the admissions which are made in the court of law have to be proved, and it's difficult to prove against the person who is himself telling it. And there are certain conditions which you follow to prove that. Okay. Section 22 talks about when is an oral admission as to contents of documents are relevant. Now, this is very important section as far as admissions and evidence act is concerned, because you may say anything orally, but can you really prove it? That's the main crux of understanding of admissions. So oral admissions as to the contents of a document are not relevant unless and until the party proposing to prove them shows that he is entitled to give secondary evidence of the content. So it all means that if a person is trying to prove a document orally, say I come and say to you that, ma'am, this driving license is true because 1, 2, 3, 4. So what is that one? I am entitled to give a secondary evidence with respect to the contents. I may say, okay, I have given the driving test at the RTO. There will be certain documents over there, correct? So that will be secondary document, secondary evidence, which proves that the content in the document that I am giving, that's the driving license, is true and that it is genuine. So the genuineness of the document has to be proved because that is in question. Now we come to confessions. Now what is a confession? Your mom asks you, did you have a chocolate milkshake today? You want to lie. No, mom, I did not. But then you think, why should I lie? My mom will accept. And you say, yeah, mom, I had, and it was chilled, it was cold. That's a confession, right? You're confessing. Like you might have heard or you might know that there is a confession box in churches, right? Where you go and tell father that, oh, I've done such and such thing. You confess, right? So section 24 to 30 in chapter 2 of Evidence Act talks about confessions. Now, first section 24 talks about confession, which is caused by, as you can see, these three words are very important. One is inducement. Inducement, someone else is telling you to do it. You are not in a position, you don't want to, you're not in a frame of mind to go and confess. But somebody is just telling you, no, you go. And you have done it. That is inducement. Other one is threat. Okay, so the person has threatened you. Say, let's take the same example that you have confessed to your mom that you had a chilled chocolate milkshake. What is inducement? Your friend may say, oh dear, that's not good to lie to mom, na? Let's go and tell. Okay, we had, let's tell, let's confess. You also thought, yeah, I should tell mom. That's inducement. Second is your brother knows about it and he says, you go and tell mom, otherwise I will go and tell her that you had. Then you will be punished. It's a threat. He's threatening you to confess. So you go and confess. Okay. And third is promise. Your dad tells you, no dear, it's not good to talk lies with mom. You go and tell mom the truth. I will give you a Cadbury. He's promising you, right? Very sweetly, he's promising you something and you go and confess. So these are three important ingredients as far as confession is concerned in section 24, when irrelevant in criminal proceeding. Now, in criminal cases, when confessions come into picture, either of these three ingredients are included and it becomes irrelevant. So as an advocate, as a good advocate for your accused, you should be disproving or rather trying to prove that the opposite side, who is the state, the prosecution, is not given good or conclusive evidences and you want to make them irrelevant. So section 24 is basically focusing on inducement, threat and promise. Section 25, confession by police officer not to be proved. Now what does this mean? Means that if there is a confession made to a police officer, it can't be proved against the person. As you know, there is something called a self-incrimination and it is not official, or rather I would say it is not really a conclusive proof as far as admitting the crime in the court is concerned. Section 25 talks about that. Section 26 talks about confession by an accused who is in custody of police. Okay, so when he is in custody, obviously he is not there and eating nice food and having fun, right? He is in the custody of police. Police is going to extract information from him and they are not going to treat him well. Obviously, it's not your home and they are not your family. So in such a situation, when the accused is stressed, he is under a lot of, say, tension. Whatever he confesses can't be proved against him because you have to give certain evidences whether he is guilty or not. You can't just say he has admitted, he is confessed. He has confessed his crime. Can you say that? No, you can't. So it lies, the whole burden of proof lies with the police. And police is represented by the prosecution in the court. Section 27 talks about how much of information received from accused may be proved. So, see, simply I'll tell you an example here. You meet your friend after, say, 4 months. Okay, you were busy with your assignments, exams, running around, internship, whatnot. And you had no time to meet your friend who just stays nearby to your house. You meet him and he starts telling you stories. This happened, that happened, I went with mom, I did shopping, I did this, I did that. But how much is relevant information? Okay, so that's the point here in section 21, which talks about whatever the accused has told. Maybe the accused may tell everything. Okay, he may tell you a lot of stories, but whatever crime that he has committed, say he has committed theft, what information is important from theft point of view is what is a confession. Others are not. Say, for example, you are asking him, you are police, you are interrogating him, and you've asked the accused, okay, so where did you go? How did you commit theft? Were there any other people with you? You had your friends with you? And he starts telling you that he ate biryani in the afternoon. He had, say, lemon juice in the morning. He visited some shopping mall with his sister. Are these all facts that he's telling? Is this information relevant as far as theft is concerned? No. What he ate, what he did, where he went, that's none of your business. What you want to know is about the theft, about the crime, how he devised a plan, how did he break into the house, who all accompanied him, what all did he steal, and where is all that kept? All those things that he has stolen from the house, where has he kept it, hidden it? This is relevant information as far as your case is concerned. So how much of information that is received from the accused is to be proved or may be proved, that is decided as far as section 27, that gives you a lead, that gives you an understanding of what is to be proved in the court. Okay. Section 28 talks about confession made after removal of impression relevant. And now what is this impression? It's a little understanding of the fact that if a confession is made, which is referred to section number 24. Now we saw what was section number 24, a confession which is made because of inducement, threat, or promise. Remember, your friend told you, your brother threatened you, and your dad promised you. Okay, so this section 28 is in relation with section 24. Okay, such kind of a confession is made after the impression caused by any such inducement, threat, or promise has, in the opinion of the court, been fully relevant, been fully removed. It is relevant. So basically, if you discard the inducement, threat, and promise part from the confession, is the confession relevant as per the court of law? So they are trying to imagine two situations. You signed, say you transferred your property to B willingly, is one situation. Other situation is B threatened you to transfer that property. Now, as far as section 28 is concerned, the court will try to evaluate both the situations. If there was absence of threat in this case, is the confession relevant? Yes or no? So they're just trying to understand. Maybe you are telling that he threatened. Maybe there was no threat. How you are going to prove and how he is going to prove that whether he threatened you or not is what is important. And court will try to understand both the situations to evaluate the situation, to understand what actually happened, okay, and how the crime was committed. That's what section 28 talks about. Now, section 29 talks about a very important point, which is promise of secrecy. So say I give you a box of chocolates and I tell you, don't tell my mom. I want to keep it secret. Now you have promised me of secrecy, but going ahead, such a situation arises that you have to blurt out the truth to your mom or maybe my mom. We are friends and you tell her. Now secrecy is gone. So whether this promise of secrecy is otherwise relevant or not. So if there was absence of secrecy, whether this confession, so you telling your mom or telling my mom is considered as a confession, whether that confession is relevant or not is what section 29 talks about. Section 30 talks about consideration of proved confession for same offense. Now you have to understand that section 30 is pertaining only to jointly under trial. So there are 3-4 accused, okay, and they are jointly under trial in the same case. Then that confession, whether it can be considered or not. I'll tell you an interesting case. A is a repeat offender, okay. He is in jail. He's being interrogated by the police. And during investigation and interrogation, he tells the police that B is my friend and he is involved in my crime. We both together did the crime. So he has dragged B also in the case. Now B has also become a co-accused in the matter. Now they both are jointly under trial. Okay, so the case will look like, say, state of Maharashtra versus A and B. Okay, so you might have read things like state of Maharashtra versus A and another. If there are many, that there will be A and others. Okay, so there are maybe 2-3 people involved in the crime. So they're jointly under trial. That will not be a separate case. So whether that confession can be considered because they have committed the same crime, same offense. That is what section 30 tells us, whether that can be considered or no. Now we come to an important part. This is a very interesting topic here, is an expert opinion. Now from what you understand from the words expert opinion, is what is given in section 45, opinions of experts. Simply, if I have to tell you, there is a case going on, okay. A has written a will. A will is a document wherein a kind of property, whether movable or immovable, is transferred in the name of some other person. Okay, so A has written a will in the name of B. So A has essentially, say, transferred 200 crores of property in the name of B. And suddenly C comes into picture after death of A, and he says, I also have a will wherein A has transferred the property of 200 crores in my name. So now you see that A has written will, 2 wills is what is in the court. Okay, A has written 2 wills, one in the name of B, one in the name of C. Both have wills and same property, 200 crores, same property. Okay, now whether B is lying or C is lying, because both can't have that will, right? One is true, one is fake will. Now we have to evaluate. So prima facie, what the court will do? Simple understanding or logic, you will see whose signature is valid or actually A's signature. We have to evaluate that. Now, if you see signatures like this, will you come to know whether it is a signature or the other one is a copy? You can't understand. So there is someone called as handwriting expert. That's exactly given in section 47. Now, this handwriting expert has his own methods and devices to understand the truthfulness of the handwriting. Okay, so your signature is also considered as handwriting, and he will evaluate. That's called forensic report. So he will give a handwriting forensic report in the court of law to prove that B has a valid signature. It's actually A's signature, and C's signature is someone else has done it. Maybe C only has done it. So that's what is opinion of experts. So he is a handwriting expert who's called in the court and summoned in the court, and he will give his opinion as to his analysis. He will say, this is my analysis, this is the document that I have prepared, that this is the forensic report, and yes, the will that B has is actually bearing the correct and true signature of A, who's dead now. So that is opinion of experts. Section 46 talks about facts bearing upon opinion of experts. So what it means, facts bearing upon, it just means that we can rely upon certain facts which are relevant in the given case, okay, and they may support your case. In some other situation, they may not be relevant. Say there is a will of X and Y. How is will of A relevant over there? No, it's not. So it's only pertaining to our case. That's what it means, section 46 says. And whether that fact, relevant fact, is supporting and is in consistency with the opinion of experts, that makes it relevant. So basically, it talks about relevancy of a certain fact that A has given will to B with a valid signature is a fact, and it bears an opinion of the handwriting expert that yes, the will that B has actually has the sign or the signature of A who is dead. Okay. So 47 is about handwriting, which I have already explained. How is it relevant? That depends on the document that the handwriting expert will produce in the court. Okay. Next is section 48, which talks about opinion as to existence of a right or a custom. Now, whether a right or a custom is relevant or not, that depends upon a considerable class of people. Say, for example, simplest understanding would be, you might have known in family law, there is a certain section in South India, they have their own rituals while marriage, performing marriage. They have certain customs, okay, their own customs. Now, to express or to prove the truthfulness or validity of such a custom, you and me are not the right people. We don't know. We are not from that community. We stay far off in Bombay. So who will tell us that? Somebody from that community, right? So he may be considered as an expert. Say a village panchayat head, an old guy who knows that the custom is being followed for last 60 years. He's 90 years. He will tell you, yes, this is the custom that our community follows. So he is an expert in that matter, and his opinion will be valid and taken into consideration under section 48 when you admit it in the court of law. Section 50 talks about relationship. Now, opinion on relationship, when is it relevant? Basically, this pertains to family laws when it comes to cases like divorce. So, say for example, A and B have been, okay, A and B are both from Bombay and they shifted to Bangalore because they got a new job. They are staying there as husband and wife. Now, all the neighbors, all the friends from office know them as husband and wife. So, apart from all the documents that they can produce to prove that they are married to each other, these people can give their opinion that yes, we have seen them and they stay as husband and wife in so and so place. That opinion is admitted in the court of law to ascertain that yes, they are married. Not everybody has a marriage certificate is also a question. Okay, some people don't even have photographs. So these people will come into picture and they will actually ascertain or rather confirm that they are a couple. They are husband and wife and they are married to each other. Now, why married to each other is important to be proved? Because they want divorce. You won't get divorce unless you are married, correct? So as far as opinion on relationship, when is it relevant? When people know around you, know that marriage has taken place or they are in that relation, they have a kid. There is somebody who's been in your contact for a long while and they know the fact which they can ascertain in the court of law. Now, dying declaration. This is a very interesting topic. Dying declaration is basically, I'll give you a simple example. There was this girl who was being harassed by her in-laws, okay, in her matrimonial home. She was writing letters to her mother saying, I'm being harassed, I'm being kicked, I'm being slapped, I'm being not given money for my expenses. These people have taken away my jewelry. These people are not letting keep my salary with me. Okay, all this harassment she's going through, and she is writing on and off every week. She is writing a letter to her mother. Okay, now you may say, why will she write a letter in today's time when we have nice WhatsApp messages which could be sent, right? But in rural areas, this is what is going on even today. And she's writing letters, say 5-6 letters she has written on and off till date. One fine morning, her mother comes to know that she's no more. She's dead. She collects the letters and she goes to the court through an advocate. Now, these letters become important evidence a very important proof in the court of law to prove that she was being harassed by her in-laws at their home. These letters, because she's dead now, they will be considered as dying declaration. You might have heard about Nirbhaya case. Her statement was taken when she woke up after a few surgeries were done, and she gave a statement. After some time, she gave another statement, which was in consistency with the first statement. She has given such, I believe, 2 or 3 statements. And later on, after recording of those statements, she passed away. So these statements were considered as her dying declaration, which actually led conviction of the accused. Now, why is this dying declaration so important? One, because in evidence or in general in criminal law, first witness is the victim herself or himself. He or she knows exactly what has happened. No other person, no other onlooker can tell what and how happened like the person himself or herself, the victim, would tell. And secondly, we believe that we, as in law, believes that nobody would lie when the person is dying. He would 99.99% times tell the truth. So dying declaration is considered as a conclusive proof in the court of law when such cases come into picture. Okay. It is given in chapter 2, section 32, which is important from your, I think, short notes point of view. And dying declaration is a very favorite question of examiners most of the time because it is so important. Rather, I would say it is crucial from litigation point of view. That's the reason why this is a very important topic. Now, I have explained, but just let's go through. Dying declaration are what? They are statements. Basically, they are statements made by persons who cannot be called as witnesses. Now, how can you call the victim as a witness? She has passed away. She's no more in this world. Can you call her? No, you cannot. So, she has given are considered as proof under this section. Cases in which statement of relevant fact by person who is dead, as I mentioned earlier. And it also talks about people who are not found. Say, for example, a boy was kidnapped in bright daylight and he was not found even after 5 days. And there is a phone call which was made to his father by him somewhere after getting kidnapped. That will be relevant in this case because even after 5 days, the police is not able to find him. But this phone call and whatever information is given on the phone call to his father will become relevant information or a relevant proof in the court of law as far as dying declaration is concerned. Okay, so it doesn't necessarily mean that the person should be dead. It could be that the person is not found. Now, I'll tell you an interesting case in UK. Such a thing happened. I'm sure you must have watched Baby's Day Out. There was a case actually wherein a little boy, a little baby, was kidnapped from his house and he was killed and burned, buried in the backyard of the bungalow. That happened in UK, and police was trying to search like crazy. But even after 10 to 15 days, they were not able to find the little kid. And finally, they came to know that he was buried just behind in the backyard. So basically, in the first situation, he was not found. So if there is any information which is relevant to him before kidnapping, that could be considered as dying declaration or a statement which is admissible in the court of law, and it becomes a relevant thing. Now, he was not found because he was killed, right? But we didn't know that he was dead. So that's why also the factor that someone who's not found is included in this section. Now, there are certain factors that they have given 1 to 8 in section 32, out of which first is important in case of cause of death. Now, as I said, the girl kept writing letters to her mother. She is telling how she is being harassed by her in-laws in the letters. That's the cause of her death. So this letter, all these 5-6 letters will be considered as dying declaration by the girl because it declares the cause of her death. 6th point is talking about will or deed relating to family members. So basically will is declaration, right? and the person is dead now. So that is again a relevant statement. And 8th point is, it is made by several persons and expresses feelings relevant to matter in question. So all these several, 2-3 people are there and they all are talking about the same thing. Then that is also relevant. It only means that what, say A has said something, B is saying the same thing, C is saying the same thing, and D is also saying the same thing. So there are several persons. B, C, and D are basically supporting the statement given by A, and they are corroborating it by their statement. And hence, the statement becomes relevant as far as dying declaration is concerned. Okay. Now, chapter 2 also talks about when is character relevant. Very interestingly, criminal law talks about antecedents. You might have read, there are in majority, in bail applications, it is written he has no criminal antecedents. He is of good character and hence he deserves to be released or enlarged on bail, because we have a thumb rule in law, bail and not jail, right? So basically we don't believe in keeping a person in jail and making him suffer. We can release him, let the trial go on, and then in the course of time, either acquittal or conviction may happen. We don't believe in keeping him inside the jail for no reason. Okay. So character of that person is, it's implicitly written that he is of good character and he has no criminal antecedents. Now, whether this is relevant or not, in criminal law also there is a thumb rule that unless a person is proven guilty, as I said earlier, he is presumed to be innocent. Say for example, I had a case where the person had 10 cases on him. But does that really mean that the 11th case that I am fighting for him, he has committed the crime? Say for example, you have a habit, a very simple common example, you have a habit of stealing sweets from kitchen and eating. Say 10 times you've eaten. Does it necessarily mean that 11th time when the sweet has vanished from the box, it is you who has taken it? It could be your brother who silently taken it, and now mom thinks that you have stolen it because you have done it 10 times. Why not the 11th time? But have you really done it? No. So whether it is relevant or not, that's what the question is. Section 52 talks about civil matters. Now, this is relevant not only in criminal matters, even in civil matters. So, character of the person is irrelevant. Say, for example, he is a repeat offender, he is a thief, and later on, he is involved in a property matter. Okay, his father owns a huge land in village, and he is a thief. He's a declared thief. Now, is that really relevant that he's a thief? No, it's not. It talks about the property that his father has, whether it can be transferred in his name or not. That's his father's wish. If it is an ancestral property, according to law, whatever share he will get, he will get. It's not that he won't get because he's a thief. So these are two irrelevant things, right? So character of that person is not relevant as far as civil matters are concerned. Now, when 53 talks about previous good character relevant in criminal matters, you may be thinking that why is it relevant? In criminal matters, as I spoke about criminal antecedents, but you might have heard of people being released from jail earlier, prior to the date of release, just on the fact that he has a good behavior in the jail, right? So if the person has good character, it becomes a relevant point in criminal matters, where you can say that, oh, he's just the first time that he is approaching the court and he is being held responsible for such and such crime. He has not done anything previously ever in his life. He is a very good person. He has a good character. He has a good standing and image in the society, and people around him really believe him to be a nice person. All these points will be relevant when it comes to criminal matters. Now, also, if you see section 54, it talks about previous bad character not relevant. Now, why is it not relevant? As I said, 10 times he has committed the crime. Does that really mean 11th time he has committed the crime? Or the case that is in front of you is what you are saying, that it's the 11th offense that the person has committed. But is it true? May or may not be true. It doesn't mean that he has done 10 times, so he will do. It may have happened that after 10th crime that he committed and he got acquitted or whatever that has happened, after that he decided, no, I shouldn't be now stealing things. I have a good family. My mom and dad are good. I have a job now and I don't want to do this thing. I want to be a good person. So his previous bad actions, bad character should not be considered, or that's not a relevant fact to be considered when it comes to criminal matters. You shouldn't be looking upon people as a repeat offender. That's what our law says. He should be given a fresh chance, an opportunity to really get into good life. Otherwise, he'll get dragged in certain crimes and repeatedly that vicious circle will go on happening. That's what our law says. Basically, the thought behind this whole concept is that every person should be afforded an opportunity to give up bad things, and there should be certain kind of an understanding, and the person should get into good life, should become a good citizen of the country. So we are giving them an opportunity, a chance. Section 55 talks about character as affecting damages in civil matters and applicable to the plaintiff. Now this section 55 is applicable only to the plaintiff. Plaintiff is the one who actually files the case. It's a property matter. It's a civil suit. It's a civil matter. So character is important as far as damages. Like I said, if it's a defamation case, right? So the person is directly, A is directly attacking on the character of B. So if B has a higher standing in the society, the damages that can be calculated will be as far as the image of the concerned person is in question. So that is applicable with respect to the plaintiff. That's what section 55 says, that the character of the person becomes a very important part. It becomes very relevant in such matter. Now, we have been talking about character. What is it exactly? It's about, like I said, image. That's your reputation, right? You have a reputation in your college. Oh, she's a first ranker. That's your reputation. And disposition. What is disposition? As I've mentioned there, it's a natural tendency to do something. Now, everybody knows you are a ranker. So you have a reputation because you got very good marks in your exams. And what is your natural tendency to do? Your natural tendency is to study more, is to score more, is to participate in all the events in the college. So that is what your character. Everybody will say she's of good character.
Madam, I need to just know about this question. I have one question. He who perceives the things by his senses can only dispose before the court, which should be discussed in the statement in relation to the hearsay evidence.
Hearsay, yes.
Can you please conclude about what are the sections related to this?
So hearsay evidence we are going to cover tomorrow. But still, I would like to tell you that as far as hearsay evidence is concerned, it is not admitted in the court. Because, say, for example, somebody told you that A killed B and you will go and tell. So you just heard it. You have not seen, you have not known, or you have not really been a part of any process that concludes that A killed B. So that is not admitted in the court of law. It's not an evidence in first place. Hearsay evidence is not admitted in the court of law. And secondly, you're talking about the bodily senses. That could be where we say that any evidence, basically the understanding of evidence is that anything that is seen or heard or felt. So basically, say you have seen some crime happening, or you have heard that somebody was shouting, in the plaints, in the petitions that come to the court, it is usually written that, say, for example, A killed B. It's not going to happen in silence. B is going to shout. B is going to create the halla-hoo, run around. So if you've seen her running, if you've seen her shouting, these are certain relevant facts which are admissible in the court as evidence. That yes, there was something wrong with her, something was happening with her. Now, if you have, apart from seen and heard, bodily senses, what it says that if somebody has touched, say, the blood that was oozed out, there was some accident that happened, and the person has actually come in contact with the blood, you will come to know there's something different. Say, for example, imagine there is a person who who is blind. How is the person going to perceive things? Through his senses, right? By smell or by touch. So that's what it says.
Okay.
Good afternoon, ma'am. I have a doubt about section 21, proof of admissions against persons making them. Can you please elaborate a bit?
Elaborate as in?
I haven't understand this section actually.
Okay, 21.
Yes, ma'am.
21 talks about proof of admission against person making them and by on their behalf. So yeah, so basically which admissions are relevant and which can be proved against so the person himself is telling something. Okay, you are yourself telling that something has happened. So whether that can be relevant in your case and whether that can be proved, that's the question. Now that depends on any conditions except for the three that they have enlisted. One is if the person is dead, the second is where there is a state of mind of the person, and third, whether it is proved or on behalf of the person. That's the question. Okay, so in a nutshell, basically the statement is made by a person. Okay, and whether that can be proved against the person. Okay, A says that he killed B. Okay, A goes to police station and he says that he killed B. Whether this fact that he's telling, he's announcing, can be proved against him, whether it can be proved that he has not done the crime, is an admission in itself, and that is relevant.
Ma'am, what is the difference between evidence and proof?
It's the same thing.
Is there any specific question that
Proof
was
is
asked
a
in the
very
previous years?
common proof is a common word that we use when you talk about it in the court of law, or now that you're writing exams, it's called evidence. Certain places you have words like you have the word proof, wherein you say conclusive proof, proof of admissions. That only means that you have to prove it. Evidence is something that is admitted. There is a very meager difference, but I think that is from a practical perspective. Right now you need to do it from an exam point of view, and it's not that relevant in your case now.
Okay, so regarding section 29, promise of secrecy, can you explain on it? You were explaining regarding the friend one, that having ice cream or milkshake or something. So believing that it will be kept a secret, if a confession is made, then it is relevant. But if this third person comes and tells it into the court of law or to the police, so will it still be relevant because it was given in secrecy?
So secrecy is only between two people. There can be a third person. Just
ma'am, please elaborate on it.
Just
I am
because
still not getting it.
Just because you promised your friend something to hide doesn't mean that going ahead you won't spill the beans, right? You go and tell it. So just because you have promised, the fact doesn't become irrelevant. We are talking about the confession which is being made, whether it is relevant or not, that we are trying to understand. Only because you promised your friend not to tell it to anybody doesn't make the fact irrelevant. It is still relevant. Okay, so basically the fact remains a fact. It doesn't become irrelevant because you have promised secrecy, because you have promised not to tell anybody. Say you saw some A murdering B. You don't want it to tell it to anybody because you're scared. But still the fact remains that A killed B. That won't change. It is still relevant. It doesn't become irrelevant because you want to hide it.
Hello, ma'am. What is the difference between relevant facts and relevant issues?
Okay. So facts are certain things that have, okay, now a crime has been committed. A murdered B. What are facts? One first fact is that A has murdered B. Two is that A went to the place where B was standing. Okay, these are certain facts which anybody can state. The person might have been captured in a CCTV camera, or somebody might have seen him doing these actions. So these are facts. And issues are certain things which are related to facts. Say, for example, someone saw him walking towards some place which is close to the place where murder has taken place. So that becomes an issue. Facts are actual something that has happened, and issues are something that you infer, you bring to a conclusion.
So Sumedha, with an example, can you explain this? I think the students will understand that much, like with some incident or some situation you can cite and explain this?
Yeah, that's what I
This
was
will
saying.
help them with their situational problem.
Anybody has a situational problem, they can tell. Okay, so basically, facts are something which get proved with respect to a crime prima facie. Okay, there is a knife, there is a CCTV footage. These are certain facts, and issues are certain things that are surrounding it. So, say for example, while A committed murder of B, A was seen talking to somebody who sells knives. That's an issue. It's not a real fact in the crime that was committed.
Hello, ma'am. Can you tell me the difference between the admission and confession?
Yeah, we discussed it in depth. Confession is a statement. Admission is also a statement, you can say, but confession is where a person goes and confesses, tells. Admission could be a documentary.
Okay.
Yeah, that's a very simple understanding is it could be more of documentary. Admission is of any proof. That could be oral, documentary, it could include a lot of things. But a confession is done by a person only. Even if it is a document, say your birth certificate is in question, but you have to go and tell, that's a confession. Only your birth certificate could be an admission.
Okay.
Is it clear? Yeah.
Yes.
Hello, ma'am.
Yes.
Good afternoon. So
Yes.
my question is related with the dowry death of a woman because of an in-laws. You said that she sent letter to her mother, and after the death, her mother wanted to file a criminal case against in-laws using the letters. Okay, but can those letter be be considered as a conclusive evidence, or some written police complaint, or some verbal recording of a statement need to filed in front of a magistrate, then that will be concluded as a conclusive evidence, because letter can be prepared by anyone. So my question is, is that a conclusive evidence, letters in the criminal?
Yes, it is, because it happens that, yes, of course, complaint in the police station is also important. But see, when a case comes to court, it is not seen so technically. A common person would not directly think of going and putting a complaint on paper in the police, especially against in-laws. In such cases, where matrimonial and in-laws things are concerned, not many people approach the police till the end, and by the end the girl dies. I've seen this happening in many cases. Dying declaration is definitely considered in the court of law as a very conclusive evidence. As you mentioned, yes, anybody can write, but then you have to prove it through handwriting expert, through forensics. There are ways of proving the letters to be true and correct. It is written in different times. All letters are not written on one day. So you can see that the ink is different. The way the ink dries, if you've written a paper, say you've noted down some points 30 days back, and you've noted down points with the same pen 2 years back, do you think that it will look same? No, it won't. Even with common sense, we can see that it looks different. With forensics being done, and with handwriting experts and other devices being used for proving that the papers are older and they are true, at the say the date is written over there, that date it was written, it is absolutely admissible in the court as conclusive proof. I have actually attended a case in High Court Bombay wherein the person was convicted because the girl died, and that's the example I've given. She had written 5 to 6 letters to her mother at different times of timeline, as in one was written in 2000 and something was written in November 2000, likewise. So they actually had to face conviction. Yes, it is considered.
So even a WhatsApp chat would be a conclusive evidence, right? Like just a WhatsApp chat expressing.
WhatsApp chat is in question because earlier WhatsApp chats were not considered as an evidence in first place in the courts of law. But these days it seems that people are using it so often that they are included. But then you should have a
difficult to prove, right? Yeah.
Supportive. Sorry?
Like difficult to prove, right? Because
yes,
like a letter, handwriting expert, yeah.
Yeah, no, that's one question. And secondly, the point is, say if I have written certain messages to you and there is an exchange of messages between us as friends, and then if I want to put WhatsApp chat as evidence, I can definitely delete few of the lines that I have said, trying to show that I have been very good to you and you have been very harsh to me. So that leaves little space for the court to not believe it as conclusive proof. Letters are not like that. Pen and paper is a different thing totally. But
Okay.
yes, these days we have WhatsApp chats. A lot of cases have WhatsApp chats as evidence, but we need corroborative evidence, as in something supportive, which proves that WhatsApp chats are true. So we need more evidence to convince the court.
Okay. You let me know whenever you would like to end. So we'll end. Okay.
So let
Yeah.
people get their,
That's resolved. Yeah.
session.
Yes.
So let them be clear with their concepts. Okay, with respect to facts and issues, I would like to add, if the person who asked the question is still online, I hope he listens to me. Facts are the incidences or the actual events that happened during the crime was committed, and issues are something that is surrounding the fact. So it's not the actual incidents or the actual act of crime that was committed, if that's what he understands.
So Sumedha, this means that with an example, I'm just asking. So suppose there's a person A, okay, and that person A committed an offense in Andheri, okay?
Okay. Yes.
So this is a fact. Right. And
Yes.
now whether the an issue is that before that someone is saying that person, a witness says that okay, that person was seen in Goregaon, another witness says
Correct.
that person was seen in Goa. So this
No.
will be a fact in
No, the issue
Okay.
will be, no, you are right, half of it is right, that the person was seen at Borivali, but the person would not say that he was only seen in Borivali. He would say that he saw him taking a train towards Andheri. That's an issue. So whether he got in the train, whether he went to Andheri and committed the offense is ambiguous. We don't know. But the real fact is that he has committed the crime in Andheri. Say we have a CCTV footage. So any person who says that he saw him going towards it, we are not sure at that point in time. Say, for example, the offense was committed. He has, say, done a bank robbery at 4 p.m. But this person has saw him at Borivali station getting inside a train which goes towards Andheri at 2 p.m. Whether it is because he wanted to plan and he wanted to commit the robbery at 4 p.m. is not sure. We are not sure. So that is an issue which has to be proved through evidence.
Okay, great.
Good evening, ma'am. I would just like to request you to give us some case laws regarding the topics which we have discussed, or in general, which we can use in our answers.
Okay, so see, for every, as I said, I will give you 4 or 5 tomorrow. But one case, I think, which if you are done with your studies and if you can really sit back and read, is Sharad Birdi Chand Sarda versus State. This is a case, if you read, you will understand the whole evidence set. It is based upon circumstantial evidence, but the way you will understand Evidence Act through this case law is like no other. Sharad, yes, because I remember my professor.
Can you spell it?
Yes, Sharad, S-H-A-R-A-D, Sharad. I can give you the citation as well. You can find it on Indian Qanun, download the PDF and read it. It's not that big and it is in very simple language. Birdi Chand, B-I-R-D-I-C-H-A-N-D, Sharad Birdi Chand Sarda, S-A-R-D-A. I'm sure those who have studied so far, they know this case. Versus State. This is a very important case in Evidence Act.
So just, because now they are running short of time. Their exam is on Monday. So Sumedha, which questions can they use this case in case you are well versed with the facts of this
yes,
case?
you can use this.
Yeah.
Okay, I'll also give the, for all those who are writing, it's AIR 1984, Supreme Court, AIR 1984, Supreme Court SC 1622. You will find this case on Google. You just type it and you get it. So you can use this for circumstantial evidence. Also, you can interpret the case in direct evidence, how that case was proved, because it was completely based on circumstantial evidence. There was no direct proof, no direct evidence. Actually, there was a murder that has taken place in this case, and some people who were related to the girl were taken in the court for as accused. Now, everything was very much circumstantial, and it's a big like landmark kind of a case for this. So you can also include it in direct evidence and say how that case talked about circumstantial, and anything that is not circumstantial is direct, where directly a case is proved. Also, you can include this case in oral burden of proof. We are going to cover that tomorrow, definitely. You can also write it in chapter 10, examination of witness. You can also take it for oral evidence. I have a case for oral evidence for tomorrow. Today's all topics were quite technical kind of points, wherein you get short notes, I believe, and long answers. And there are no case laws even in your Bare Act, if you see. So there are illustrations. A sold horse to B kind of. So I think for today's topics, you can write illustrations and be done with your answer. And
Okay, so participants, hope it's clear. We will be sharing the PPT with you all. Sumedha, again, I'm repeating that for today's whatever was covered portion, you all can use illustrations, give examples, A and B, anything like how Sumedha. Yeah.
Illustrations are very simple and they are given in Bare Act. They're very easy to understand. One, you will understand, just read one, and that's more than sufficient. The easiest one you remember, you jot it down in your paper. It will also tell you what is the section about if you are not understood so far.
Okay, great.
Okay. Anybody who has questions with respect to topics of today, after revising, if you're confused, you can ask that tomorrow.
Hello.
Yes.
Madam, can you hear me?
Yes, tell me.
It was regarding section 29, promise of secrecy. So just want to know, is it relevant regarding section 122, which includes privileged communications?
Sir, privilege communications is quite related to state matters where there's a lot of confidentiality involved. State matters as in something related to the country, something that is very confidential. Say, for example, there is certain kind of an information which is passed on by the Home Ministry to the Ministry of Defense, which involves a lot of security of the country. That could be confidential. Privilege could be parliamentary conversations, something where law is being made, as you know, in the parliament. That could be a privileged communication. Secrecy could be in any case.
Secrecy could be in matrimonial case or in professional.
Yes, definitely. Even in matrimonial cases, definitely.
Okay, also, I just need to know the section 29, if the question comes. Should I attach the section 29 with section 122 and further on?
No, please don't confuse, sir.
Okay.
The person will, even though you've explained it well, I see that you have understood the concepts properly when you say matrimonial, but sir, the person who's checking your paper may not understand that you have understood it properly and think that you're confused. So please don't mix. I would suggest only attempt section 29. Are there a lot of questions, and is it that's why you all are asking about section 29?
No, I was just asking related to the
because there were 2 students who asked about section 29. It's not that important a section is what I see, even from a practical point of view. It only says that a certain fact is relevant even if someone is hiding it. That's the point.
Good evening, ma'am. Ma'am, my question is regarding section 32 dying declaration. If somebody who, like one lady, who having so much harassment and everything from her living partner, and that time she so that time she's not using like letter anything for commandment. She using like a video convention. In video convention, she said that whatever things are going on in my life only to that person only. So can a video conference should be take for conclusive evidence in the court of law?
Yeah, as far as I think you are pointing to the recent Delhi case.
Yes, ma'am. Video conferencing, I'm asking. Yeah, ma'am.
Yeah. So see, as far as the conclusive proof is, the concept of conclusive proof is considered, it depends on the court. And moreover, see, any evidence, say if you go and say that a crime has been committed, you have to give sufficient evidence to the court to convince the person, the judge. Okay, basically it's the judge. You have to convince the court that the incident or the crime or the offense has been committed. Now, do you know that the video conferencing or videos could be made? It could be, say a person can be tutored. There is something called as face masks. So you don't know whether the person is telling the truth, one, on his own. Secondly, you don't know whether the person himself or herself is actually telling on the video call, right? So there are certain loopholes which have to be explored. Now, wherever there are loopholes or lacuna, they have to be filled with evidence which tell you surely that this and this thing has happened. The concept of conclusive proof is that it comes as a direct, attack on the fact that the accused has committed the crime. Say simplest example is, I'm talking about murder. Like, so if you have the knife with which the murder has been committed, you'll surely have the fingerprints on the handle of the knife, right?
Yes,
that
definitely.
becomes a conclusive proof. So the prosecution will say that this is a very important evidence, crucial evidence. We found the knife in the house of the accused. Also, it bears the fingerprints of the person. This is a conclusive proof as far as prosecution is concerned. Now, me being an advocate defending the accused, I will say, no, it's not a conclusive proof because it is his kitchen knife. It will be found in his kitchen only, not in neighbor's kitchen, right? And secondly, it is a knife which is in his house. It is, everybody has a knife at home, correct? So it's a knife in his own house. You are only going to use it. Now, if I have a kitchen knife in my kitchen, my fingerprints are obvious to be there because I'm using it daily, right? So a conclusive proof is something that directly points to the fact that the crime was committed, first point, and second point, that the crime is being committed that a particular person. So in totality, there are very, very few conclusive proofs which are admitted in the court, and that is the reason why we require a lot of evidences to prove our case. Because as I said, 99.99% times there is no direct evidence. You are basically pleading on the basis of circumstantial evidence. Because see, someone who is committing a crime is not so foolish that he will do it in broad daylight in front of 1,000 people, right? If he's having that mens rea, that guilty mind, he will be taking all due precautions to evade the law, right? So that's the point. So the whole concept of conclusive proof is something that can very surely ascertain that the crime has been committed and that the crime was committed by that a particular person, which are very less in reality.
Okay, that crime should be related to a conclusive facts, and it depends upon the court which kind of initiative they will take.
Definitely.
Okay, ma'am. Thank you so much, ma'am.
Participants, actually, y'all are asking about case laws. So on our YouTube channel over the years, we've done a few sessions on the Indian Evidence Act, burden of proof, admissions, dying declaration, where we've deep dived into that particular subject. Today's a revision lecture, so maybe there you all will find a lot of case laws. So please, if you all have time, you all are planning to top and you all are already prepared, wanting that extra edge, so you all can look into those webinars. And even otherwise, if you all want to clear the concept, those webinars will also help.
I'll be anyway giving you some 4 to 5 case laws, which in general you can write very safely in your answers. One is Sharad Birdichand Sarda. You can include it in quite a lot of topics with respect to evidence, circumstantial, direct, oral confessions, investigation, and those sort of.